Welcome to This Explainer. Look, as former USPTO patent examiners with over 25 years of experience, we're coming to you today from the perspective of our Washington, D.C. firm, IP Boutique Law. We've sat on the other side of the desk. We know exactly how design applications are evaluated from the inside. And today, we're going to pull back the curtain and show you how we review these applications straight from the examiner's chair.
Here is our roadmap for today. We'll cover 4 key areas. First, ornamental versus functional limits. Second, categories that actually qualify. Third, exactly what examiners will exclude. And fourth, why your patent drawing strategy absolutely matters. Let's get right into it.
Section 1, ornamental versus functional limits. So we have to start with the single most critical threshold. This dictates whether your application even survives before the real examination begins. The entire foundation of design patent eligibility comes down to 35 U.S.C. Section 171. This statute demands a design be new, original, and ornamental. Now, in our experience, it's the nuances of that ornamental standard that trip up most applicants. A design patent strictly protects how an article looks, not how it works. You have to understand the contrast here. Just because a product is highly functional, like a smartphone or a sculpted car hood, doesn't automatically disqualify it. If your design could have taken on dozens of different forms and you chose one specific layout for aesthetic reasons, that's protectable. But if the shape is dictated entirely by engineering constraints, take a standard hex nut, for example, which only looks that way so it can function properly, well, that's unprotectable. When we're examining your applications, we follow MPP Section 1502. We are actively hunting for those visual, ornamental characteristics. What we want to see is documentation proving that your specific aesthetic choices were made totally independent of engineering requirements. We always advise our clients to clearly document why they made certain aesthetic choices, because having that paper trail right there supports your claim of ornamentality when an examiner inevitably pushes back. Moving on to Section 2, categories that qualify. The USPTO outlines specific categories that span across a wide range of industries. We regularly issue patents for physical product configurations. Think the unique shape of a beverage container or the silhouette of a piece of furniture. We also approve surface ornamentation. This could be a repeating decorative motif on wallpaper or a graphic treatment on a phone case. The catch? It has to be a definite, reproducible design, not just the result of a random manufacturing method. Here is a crucial point. A design claim is legally inseparable from the physical article itself. Back in 2021, the Federal Circuit made this incredibly clear with the In Re Surgisil ruling. You cannot patent a shape in the abstract. In that specific case, an applicant tried to claim a shape for a lip implant and then turn around and enforce it against a completely unrelated article that just happened to share the same shape. We will reject that every time. Your protection is strictly limited to the exact article of manufacture you identify in your claim. That actually brings us to a highly valuable yet tricky category: software and graphical user interfaces. For software companies, we need to see GUIs claimed specifically as they are displayed on a screen. If you just submit a standalone icon as a digital image, we're going to reject it because it isn't tied to an article of manufacture. But if you take that exact same icon and show it displayed on a computer screen or display panel, suddenly it meets the requirement perfectly. Apple's massive portfolio covering their iOS interface elements is a textbook example of doing this right. Section 3. What examiners will exclude? You have to understand that the strict grounds we use to actively reject applications to avoid costly delays. Examiners apply a much higher standard than just asking, hey, does this look nice? We've examined plenty of applications where the design looked really distinctive, but we still properly refused them. Why? Because if a sleek, aesthetically pleasing design was selected solely because it reduced wind resistance or, say, improved grip, it simply does not qualify. The appearance has to be totally separable from the functional rationale. As examiners, we are actively looking for these 4 specific grounds to issue a rejection. If your design is the inevitable result of functional choices, it's out. If it's a non-repeatable chance manufacturing result, meaning you can't define and reproduce it consistently every time, it's out. And, just like we discussed with that lip implant case, abstract designs not tied to a specific physical article will absolutely not survive examination. Another massive hurdle is visibility. We evaluate designs through what's called the ordinary observer standard. We will flat out deny protection for underside surfaces that face away from view or internal components that get completely concealed during assembly. Basically, if an ordinary observer cannot see the aesthetic feature while the product is engaged in its normal, intended use, we consider it unprotectable. It's as simple as that.
Section 4, Patent Drawing Strategy Matters. Let's talk about the most consequential decision in design patent prosecution. In a design patent application, there is only one claim, and it refers entirely to your drawings. Therefore, your strategic use of solid and broken lines defines exactly what you own. Solid lines? That's your claimed ornamental design. That is the core of your protection. Broken lines provide the context, like the surrounding environment or functional features, but those elements are expressly excluded from your protection. Mastering this interplay allows you to carve out functional features and stop competitors from easily designing around your patent. Following the landmark 2016 Supreme Court decision in Samsung v. Apple, you aren't limited to claiming the entire product anymore. You can protect very specific components. Apple executed the strategy flawlessly. They showed much of the iPhone's design in broken lines. That meant Samsung's differences in those specific areas were completely irrelevant to the infringement analysis. By isolating specific ornamental parts like the screen proportions and the rounded corner geometry in solid lines, Apple pinpointed exactly what mattered for infringement. Let me tell you, as examiners, we review your broken line usage with incredible scrutiny. If your broken lines are inconsistent with your described claim, or if required views are missing, we'll reject the application right there. Getting this blueprint perfect at the filing stage, right after conducting a thorough patent search, is literally what separates a vulnerable, weak patent from a defensible one that survives our examination and holds its ground in the market once granted. And the reward for getting it right is substantial. For applications filed on or after May 13, 2015, a granted design patent provides a solid 15-year term from the date of grant. And notably, unlike utility patents, which require hefty payments at 3.5, 7.5, and 11.5 years, design patents require absolutely zero maintenance fees. None. They stay in force for that entire 15-year term. One highly effective strategy we routinely advise for our clients is layering these protections simultaneously. You utilize a utility patent to lock down how a product works, a design patent to protect exactly how it looks, and trade dress registration to secure the overall brand identity. By stacking these different legal theories, you create a dense, overlapping web of coverage that significantly raises the cost and the difficulty for any competitor trying to knock you off. With over 25 years of USPTO examiner experience informing our approach at IP Boutique Law, we literally look at applications through the patent office's eyes. We know the exact arguments examiners will use to deny functional designs, and more importantly, we know how to structure your claims and drawings to withstand that intense scrutiny and maximize your protectable scope. So, look closely at your planned application. Before you file anything, you have to evaluate: is your application built on a truly defensible ornamental foundation, or are you walking blindly into a guaranteed rejection? The difference lies entirely in understanding the examiner's perspective. Are your drawings just hiding functional flaws, or are they strategically highlighting your protectable aesthetics? Think about that carefully. Thank you for joining us for this explainer.